Good afternoon. Waited a little bit longer than usual to get started because of the worse than usual traffic outside, but I think it's time to start. My name is Dave Schultz. I'm a member of the faculty here at the law school, as well as Associate Dean for Continuing Education and Outreach. And on behalf of the faculty and staff of the law school, I welcome you to today's event, which is the 12th Thomas E. Fairchild Lecture. I'm filling in today for our Dean, Ken Davis, who always does such a good job in welcoming you to events like this. Ken is unable to be here because he is in Asia, meeting with some of the university's partners in that part of the world. He asked me to communicate his regrets. I want to remind you that immediately after the lecture, a reception will be held to which everyone who can hear my voice in this room and upstairs is invited. The reception will be in what we call the Lou Bar Commons, which is room 7200 of the law school, 7th floor of the Hearst Faculty Tower, accessible by an elevator on the floor here. We'll have people outside the room if you need help navigating our building and help you get up there. I really welcome the opportunity to fill in for Ken Davis today because our office, that is the outreach office in the law school, has had the good fortune to be able to staff and support the Fairchild Lectures since 1988 when they began. These lectures exist because Judge Fairchild's former law clerks and interns wish to honor him by having events like this in his name. You have a program for the function today, and all of the judge's former law clerks and interns are listed there. For the benefit of the many students who are watching the lecture either here or in one of the other rooms, I just might briefly note that Judge Tom Fairchild is one of the very distinguished graduates of this law school. He served as a justice on the Wisconsin Supreme Court from 1957 to 1966, when he was appointed to serve on the U.S. Court of Appeals for the 7th Circuit. Again, your program has a more complete summary of Judge Fairchild's career. The high regard in which the legal community holds Judge Fairchild is shown, I think, by the individuals who have given this series of now 12 lectures. And again, a full list of those prior speakers is also in your program, along with a citation to the printed version of each of those talks, which have all been published in the Wisconsin Law Review. I think today's speaker will fit in well with the distinguished predecessors. To introduce him, I turn to my faculty colleague and friend who's made impressive contributions of his own in teaching, research, and service on criminal justice topics, and that's Professor Walter Dickey. Walter.
Thanks, Dave. Let me add my own words of welcome on behalf of the faculty, staff, and students of the university to this distinguished lecture. And let me also add a special word of welcome to Judge Fairchild, whose presence really honors us today. You have in the handout the biography of Stephen Bright, and it's a very impressive one. And given the fact that you've got it, it seems really not useful for me to sort of go over it all, though I do want to say that knowing more about him and his work than is contained in that little biography, I think it's fair to say that it really does not do justice to his contributions and achievements in criminal justice as well as in human rights matters. It might be useful to just reflect very briefly, though, and to put in context some of the work that he's done. I think anybody who's worked in the criminal justice system or who has observed it would find it very hard to believe that it functions fairly, smartly, in any sort of way that approaches what we would like a criminal justice system to function in a democratic society. We ask it to do all kinds of jobs that it really cannot do, that I don't think any system can do. In many ways, we ask it to do jobs that I sometimes think require the subtlety and tools of a surgeon, a highly trained surgeon. And yet we give it the tools of a lumberjack to carry out those very important and subtle kinds of functions. But the fact of the matter is we have it. It's not going to go away, and basically we're responsible for it. And I think if it's in anything like the sort of condition I suggest, and it's here to stay, then it is an institution and system badly in need of reform. I think recognition of that prompts reflection on questions such as what would have to be true for reform to occur. And I think, quite honestly, the list is quite a bit longer than we could even rattle off in an evening such as this. Though I do think it's worth trying to note a couple of what I would think would be the most important qualities that would have to be brought to bear if the system were going to approach the kind of system I think we should aspire to. If it's going to be changed, it seems to me we need new knowledge and information and ideas. The sort of old way of doing business as usual, clearly is not good enough. I think, secondly, today we need expression of those ideas. We need fearless expression, really, that run against the sort of muddle of what I think of as the current thinking and the current river of the criminal justice system. That expression, fearless expression, I think can come in a lot of different forms. It can be reflective. It can come in the form of advocacy. It can come in the form of teaching. There are a lot of different forums in which we need it and in which it really ought to be available to all of us. I think in conjunction with both of those thoughts, new ideas and expression, we need new ways of doing business. We need new approaches. One of the things that I say to law students is, we're not here to make you critics. We're here to make you playwrights. We want you to be problem solvers. We don't want you simply to be people who can observe and tell us what's wrong. We need people who are going to help us make it right. And so it seems to me ideas about redefinition, redeployment are things that we're badly in need of if the system is going to be improved in the way that I think it should be. And finally, I think we need inspiration. We need inspiration and we need preparation. We need attention not only to our peers, but attention to the young people, law students and others, because it seems to me the future is very much in their hands. And unless they have observed the kind of qualities that I've just mentioned, have been exposed to them and have been inspired by them and have models that make them want to be like that, it seems to me the sort of long-term health of the system cannot be good, though if we have it, I think it can be. Because this is clearly a job that's going to take time. My generation is certainly not going to fix it, though we have to have hopes that the next one and the one after that will. I mention all of those qualities because it seems to me, knowing what I do about the work of Stephen Bright, he really in many ways exemplifies them. I think it's fair to say from the biography that you've seen and from the work that I know that he's done, he is a person who is full of ideas. Those ideas are expressed clearly and fearlessly in a variety of different settings, teaching, advocacy, expression in meetings such as this. He's not just a critic, he's somebody who has made suggestions about how we can approach problems in ways that create greater value in our society. And I think there's very little doubt that his work has been an inspiration to law students, to lawyers, to members of the public, and to others who are concerned about these important problems. So for me, someone who's devoted a lot of his life to the criminal justice system, inspired by Frank Remington as I was, I think it's really a great honor to introduce Stephen Bright, because he really does exemplify those qualities that I think we really need to see more of if the system is going to be of the kind that we want it. Thank you.
I think I've got you wired up here. Thank you.
Thank you very much. You're very, very kind. My voice carries pretty well, I can tell you that. Thank you. I'm not sure that everyone would agree that my advocacy has been as fearless as some would probably say reckless, but I appreciate the spin that you put on it. And I want to say how honored I am to be here, and thank you for inviting me to give this lecture named for Judge Thomas Fairchild, a great judge. When I looked at the other people that had given this lecture, and I don't know that I really do feel like I fit in there with Supreme Court justices and great scholars and Lawrence Walsh and other people. I remember what Justice Brennan said when President Eisenhower appointed him to the Supreme Court. He said he felt like the mule that had been entered in the Kentucky Derby. And he said he wasn't sure if he really belonged there, but he knew he'd benefit from the association. I'm not sure that I will acquit myself as well as Justice Brennan did, but I have the same feeling. But I do want to acknowledge Judge Fairchild and Ms. Fairchild. And I know that was at a time when presidents of the United States appointed great jurists to the courts, and the courts were in the business of protecting people's constitutional rights. I practiced law in the Deep South, and just about everything that's happened in the Deep South that's been an accomplishment or a move forward, whether it's in the schools, whether it's in the criminal justice system, whether it's in the prisons, whether it's in the mental health institutions, it came about because federal judges ordered it, because Judge Tuttle or Judge Frank Johnson or Judge Minor Wisdom or some of the other great federal judges who are memorialized in a book by Jack Bass called Unlikely Heroes stood up against the time and protected the rights of people there. I saw Jack Bass the other day. I said, if you wrote that book today, you'd have to call it The Unlikely and stop there, given who's on the courts today. I know there are many former clerks and admirers and other people of Judge Fairchild here. I want to thank them and all of you for coming. Judge, I want to also thank John Skilton for arranging this, but I particularly want to thank Francis Hurst, whose husband, Willard Hurst, of course, was a great law professor here, but Francis Hurst herself has been a great force for good in this community for her entire life, and I am extremely fortunate to, in some small way, be related to her, and I'm honored to be here, and Francis, I'm honored that you're here tonight. Thank you so much for this afternoon. And I want to thank all of you for taking time out of being wooed by the presidential candidates to come here. I know how tough it must be living in a swing state. I'm living in a write-off state. Nobody's come. When they do come, everybody runs for another part of the state every time the presidential candidates come. So we don't have the problems that you have here, the attention you have here. I guess they're not problems. You might say Wisconsin doesn't have the death penalty, but of course you do have the death penalty because of federal death penalty. In 1988, the federal government adopted the death penalty for so-called drug kingpins. First person to get it was a fellow who dealt marijuana in Alabama, not exactly the person we might have imagined when the law was passed. And of course, in 1994, Congress passed a crime bill which federalized a number of crimes and provided for the federal death penalty, and I'll come back to that in a moment. But let me start off just by saying a couple of things. Justice Arthur Goldberg once said that the deliberate, institutionalized taking of human life by the state is the greatest conceivable degradation to the human personality imaginable. And so I think even though the state of Wisconsin doesn't have the death penalty, it's worth some of our time to talk about it and talk about its use in our country and to look at where we stand in the rest of the world with regard to this irrevocable, extreme, and enormous punishment. About 6 months ago, the Parliament of the Ukraine voted 229 to 15 to abolish the death penalty in the Ukraine. And that brought to 38 the number of states that since, or the number of countries since 1985 that have abandoned capital punishment. During that same time, only 4 countries that didn't have capital punishment have since adopted it, and one of those, Nepal, has since abolished it. Only one other NATO country has the death penalty today, and that's Turkey, which hasn't executed anyone since 1984. And Turkey is expected to soon abolish capital punishment so that it can join the Council of Europe, because you can't be a member of the Council of Europe if you have capital punishment. That's why Russia, Poland, and other Soviet bloc countries no longer have capital punishment. If you had said to somebody 25, 30 years ago when I was in law school, which 3 countries will have the death penalty at the start of the new millennium, Russia, South Africa, and the United States, how many people would have guessed 25 years ago that the only country would be the United States? In fact, last year, 4 countries accounted for 80% of all the executions that took place in the world: China, Iran, the Congo, and the United States. Since 1990, only 6 countries in the world have executed children, that is, people who were under 18 at the time of their crimes: Iran, Nigeria, Pakistan, Saudi Arabia, Yemen, and the United States. And in that rather undistinguished company, the United States leads by far in the number of people who were children at the time of the crimes who it's put to death. In fact, our country is one of only 2 countries that has not ratified the International Covenant on the Rights of the Child. The other country is Somalia, which not even sure has a government. And the United States has not ratified that covenant because it would prohibit the execution of people who were children at the time of their crimes. While the rest of the world is increasingly abandoning capital punishment, 38 states and the federal government have it. And increasingly, the jurisdictions within our country that use capital punishment are becoming sources of curiosity and condemnation for the rest of the world. Our ambassador to France tells us that everywhere he goes in Europe, the thing he's asked about the most and the thing the United States has criticized the most is its use of the death penalty. France abolished the death penalty in 1981. Other countries complain when we execute their foreign nationals who are here, and particularly when we execute their foreign nationals who were arrested and tried and convicted and sentenced to death in violation of the Vienna Convention on Interconsular Affairs. The convention that protects all of us when we travel around the world, that says if we're arrested, that country is to notify the consul of the United States. And similarly, when foreign nationals are arrested in our country, it's the obligation of the police in the states to notify their countries. And yet, of the 17 Mexican nationals on death row in Texas right now, not a single one was the consul notified. Not a single one was advised of their rights under the convention. And so it's appropriate, I think, to ask, looking at what's going on in the rest of the world and some of the questions I want to talk about that have been raised in our country, will the death penalty survive the 21st century? When we once had a frontier society, we used a lot of fairly primitive ways of punishing people because those were the only options we had. We didn't have the vast prison industrial complex that we have today. And so our options were whipping, the stocks, cutting off fingers, and executing people. And it's interesting that today, of those primitive punishments that were employed by a frontier society and by the world in more primitive times, the only one that has survived is the death penalty. Even in Alabama, they don't cut off fingers anymore. They would like to go back to whipping, but so far that hasn't been done. We would say today, if you suggested that a way of punishing someone would be to run an electric current through them just enough to hurt them, you'd say that's barbaric. But if we run an electric current through them enough to put them to death, that's accepted. And yet there's a growing uneasiness about the death penalty, even here in the United States where it's being used so much today. In 1977, the American Bar Association called for a moratorium on capital punishment, as many of you know. The reasons being the poor quality of legal representation provided to poor people facing the death penalty. The fact that race has such an important role, or plays such an important role, in who's sentenced to death. The fact that the mentally retarded and the mentally ill are often condemned to die and are put to death in our electric chairs and in our gas chambers and in our lethal injection chambers. And the other thing that I mentioned, the fact that we still execute people who were children at the time of the crime. Since that time, since 1977, when the American Bar Association said, we've been calling upon the states year after year, time after time, improve the quality of counsel, nothing's been done. Do something about race discrimination, nothing's been done. Do something about the mentally ill, the mentally retarded, the children. Some states have done something, but many have not. But then we've had the growing realization that a lot of the people we've condemned to die, just as a lot of the people we've convicted of crimes, are not even guilty of the crimes they were convicted of. And Governor George Ryan, I guess, fired the shot that was heard around the world in this debate, the Republican governor of Illinois, when he declared a moratorium on capital punishment earlier this year. Just 2 weeks ago, Governor Ryan was in Atlanta at the Jimmy Carter Center where we were having a program on capital punishment. It was fascinating to hear this man, a pharmacist from Kankakee, who got elected to the legislature, and he told the crowd there, he said, I got elected and I was for every tough crime bill that came around. I was for the death penalty. I was for locking them up and throwing away the key. I was for doing away with the appeals. And then I became the governor. Then I became the person responsible for deciding who lives and who dies. And he described the first time a case came to his desk, and he had to make that decision about whether to grant a commutation or not. And he said, I had all these questions, and nobody had the answer. I asked the prosecutors, I asked the people in the Attorney General's office, I asked others, but nobody could give me the answer to these questions. And we had executed 12 people. And then there was this man named Anthony Porter, who was to be executed. He had been convicted at a trial by a jury. He had been sentenced to death by a jury. He had gone all the way through the appellate process, state and federal. He was about to be executed. As you may know, you cannot be executed unless you can understand the reason for your execution. You have to be mentally competent. You have to understand that you're being put to death in punishment for the crime you committed. If you can't understand that, you go to a mental institution, and you're treated until such time as you can understand it, and then you're executed. It's one of the places where capital punishment sort of catches up with the logic of itself, perhaps, but Anthony Porter's IQ was 51. He had some other mental problems, and there was a question about whether this man could understand why he was being executed, and for that reason, and that reason only, he was granted a stay of execution. And it was after that that the journalism class, the undergraduate journalism class at Northwestern, became involved and proved that Anthony Porter was innocent of the crime for which he had been sentenced to death, and even got a confession from the person who did it. And what's really remarkable is this was the third person released from Illinois' death row because their innocence had been proven by the undergraduate journalism class at Northwestern University. And I was in a debate not long ago with somebody, and they said, well, the fact that these people were released shows that the system works. And I said, spending 16 years on death row for a crime you didn't commit is not an example of the system working. When undergraduate journalism students prove that lawyers, police, prosecutors, judges, and the entire legal system didn't detect the innocence of a person who's condemned to die, you can't say that system works. And Governor Ryan, with enormous courage, after 13 people had been exonerated, 12 had been executed, called a halt and said there will be no more executions in the state of Illinois on my watch until we figure out why. He said he was powerfully influenced by a Chicago Tribune series, which probably some of you have seen, and if you haven't, I recommend it to you highly, that looked at why this was happening in Illinois. And I'd say that compared to many of the states that have the death penalty, the so-called death belt where I practice, Alabama, Georgia, Texas, Arkansas, Illinois is the promised land. And they actually have lawyers for people there that stay awake during the trials. They have a public defender office in Chicago that represents people in these cases. And I'll talk about what we see down in our part of the country. It's much different. But the Chicago Tribune found that of the lawyers who had represented people sentenced to death in Illinois, a third had been disbarred, suspended, or convicted of crimes. One lawyer was appointed to a capital case the day in which he was reinstated after having been suspended from the practice of law for malpractice. 41 people on death row on the testimony of jailhouse snitches, people who traded their testimony or their freedom for testimony. And it was one of those cases, which was actually the 13th exoneration. Anthony Porter was the 12th. Prosecutorial and police misconduct, overzealousness of those who were trying to obtain convictions for whatever reason it might be, to advance their political careers, or even because they just honestly thought they were right, but they weren't. And unreliable forensic evidence. There have now been across the country, since the death penalty was reinstated by the Supreme Court in 1976, there have been 89 people released from death rows. That's people who walked free, people who were once condemned to die by juries or judges, who've walked free because their evidence was established. There have been other people whose sentences have been commuted to life imprisonment without possibility of parole because of questions of their guilt. When Douglas Wilder was the governor of Virginia, he commuted the sentence of a man named Earl Washington, a mentally retarded man. And if you want to see how vulnerable people in the criminal, how vulnerable mentally retarded people are in the criminal justice system, get the transcript of Earl Washington's interview with the police, where they'd tell him what to say. Oh, yes. Well, no, it wasn't that way, Earl. It was this way. Oh, yes. Oh, yes. And so he commuted it. I didn't think it was a very good way to treat an innocent man, to give him life without parole, but that's what Governor Wilder did, and it's a good thing he did, because now the DNA evidence just within the last few weeks has shown conclusively that Earl Washington was innocent of the crime. And of course, there have been some people that have been executed despite questions of whether they're guilty or innocent. Earlier this year, the New Hampshire legislature, in response to many of these developments, repealed the death penalty in that state. The governor vetoed it, but the legislature, both houses of a Republican legislature, voted to repeal that state's death penalty law. This state senator, Senator Feingold, has introduced legislation into Congress calling for a moratorium on federal executions. Senator Leahy has introduced the Innocence Protection Act that would do two things: provide for DNA testing, but more importantly, would provide for competent legal representation for people facing the death penalty. And increasingly, we're hearing unlikely voices like that pharmacist from Kankakee, Governor Ryan, people who believed in this system. I was on that same program at the Carter Center, where Gerald Cogan, who was the head of the prosecutor's office in Dade County, Miami, Florida, a man who stood up and asked for the death penalty as a prosecutor over and over, a man who supervised other prosecutors who asked for and obtained the death penalty, a man who became a trial judge and presided over capital cases, later became a justice of the Florida Supreme Court, and finally became the Chief Justice of Florida for a number of years, and upon retiring said that the death penalty was corrupting and destroying our justice system, and it needed to be abandoned. Moses Harrison of the Illinois Supreme Court, it says very much the same sort of things, echoing the words we heard before from two longtime people who supported the death penalty, Lewis Powell and Harry Blackmun, two Supreme Court justices, Justice Powell after he retired and Justice Blackmun before he retired, and coming to the conclusion that capital punishment was ill-advised for our legal system. George Will wrote a column saying that this is just another government program and it doesn't work. And even Pat Robertson called for a moratorium. When I read that, I started to reconsider my own position on the death penalty. And yet, despite all these caution lights being raised, totally unheeded in many parts of the country. You can go to Texas, and it's assembly line executions in Texas. Children executed. Mentally retarded executed. Mentally ill executed. Born-again Christian executed. Grandmother with grandchildren executed. Even questions of innocence. This year, two people, Odell Barnes and Gary Graham. Doesn't slow down the machinery of death in Texas. Both of them executed. I was startled. A lot of people say, well, can you prove any of these people are innocent? Gary Graham is tried in a case where he's identified by one person who sees him through a window pane. He's represented by a lawyer named Ron Mock, who had so many people sentenced to death that they literally have the Mock wing of death row. He's an alcoholic who often came to court drunk and unprepared. He didn't do any investigation in the case whatsoever. And so the other witnesses who were there, the people who were there at the scene of the crime and who later said, no, that's not the guy who did it, the guy was taller. He never looked at the police report to show that the person who identified Graham, the person who identified him through this window, had given a completely different description. Can you prove he's innocent? No. Can you say beyond a reasonable doubt he's guilty? Of course not. Can you say he had a fair trial? Of course not. And in Virginia even, they would have commuted it to life without possibility of parole. They would have said, we may not know whether or not he's guilty or innocent, but by golly, with these kinds of questions, with a one-witness identification, with a drunk lawyer, with all of those things, we're not going to let this person be put to death. No, boy. No way in Texas. What's not only troubling is not only the volume, but the cavalier way, some would say the routine way, in which death cases are treated. By the courts, by a governor who's presided over more than 140 executions in just 6 years. No other state in the Union has executed more than 80 people in the last 30 years. But one state, the Lone Star State, has executed well over 200. In fact, Houston, Texas has executed more people. More people have been executed in the last 25 years out of Houston than any state in the Union, except for Texas itself and Virginia. Houston has had more executions even than Florida. And yet, no Texas case gets more than 15 minutes of the governor's consideration, and some people are even taking him seriously as a candidate for President of the United States. Earlier this year, Florida threw caution to the wind in a rather frantic 3-day session in which it adopted 3 days the legislature met. In fact, Justice Kogan was telling me about it. He said what happened was all the legislatures were in New Orleans because Florida State was playing a football game. And they were all enjoying it, I guess he would say. And they scheduled this session of the legislature for immediately after whatever it was, the Rose Bowl, I guess. What did they play that? The Sugar Bowl. And they all came back. They hadn't read the legislation. They had 3 days. They adopted the so-called Texas model, as if Texas was a place to look for a model of how to carry out capital punishment. They switched from electrocution to lethal injection because they had botched so many executions. They couldn't wire them up right, and they kept catching people on fire, and they kept electrocuting people. They couldn't kill them. They'd try again. They couldn't kill them. So they went to lethal injection, be a little more acceptable. I think Governor Jeb Bush might have a case of penal envy, I think, in terms of what was happening. But remarkably, that session ended at the end of those first 3 days of January, and by the end of February, they were already lethally injecting people. They already had the system, had it up and running, had the poisonous chemicals flowing into people's veins. Last year, 98 people were executed, the most since 1951. We have 3,600 men, women, and children waiting to be injected, electrocuted, shot, or gassed. And yet the death penalty in the United States remains today, as it has been throughout our history, very much a matter of race and place, and very much a matter of inequity and iniquity. And I would like to talk just briefly about each of those as we think about whether this is a punishment we'll retain in the future. Sadly, our legal system is the part of our society that's been least affected by the civil rights movement. As I travel throughout the Deep South, I see some changes, almost all, as I said earlier, at the order of federal courts. I'll never forget when the first African-American lawyer to graduate from the University of Mississippi Law School was showing me around a little town called Drew, Mississippi. And everything, there's the school, we sued to integrate the school. There's this, we sued to integrate that. There's this. The most remarkable story he told me was about the baseball field. He said we had to sue to get to play baseball. Judge Cady ordered it. So then they took the bleachers and the lights and they took them out to some farm, some white farmer's farm, and they started playing out there. So then we had to file a second lawsuit to get the bleachers and the lights back. And I thought, isn't that remarkable? We had to file 2 federal lawsuits to get to play softball. But there's been changes. As I look around the South, I see African Americans now serving on county commissions, on state legislatures. I see them in the school system. But I go to the courthouse, and nothing's changed. I go to the courthouse, and I look in case after case after case, and the only person of color up there in the front of the courtroom is a person who's on trial. We know now, beyond dispute, that a person of color is more likely than a white person to be stopped by the police. That's what we call driving while black. We know they're more likely to be abused by the police. They're more likely to be put in a chokehold or otherwise abused. They're more likely to be arrested during that encounter with the police. They're more likely to be denied bail than a white person when they get down to the courthouse. They're more likely than a white person to be charged with a serious crime. They're more likely to be convicted, and they're more likely to receive the harsher sentence. In Georgia, if you're talking about probation or jail time for first offenders, you're 3 to 6 times more likely to be put on probation if you're white than if you're a person of color. And part of that, I think, is because the Georgia judges unconsciously, people who are trying to do their job in good faith, but when they see that young white man in front of them, they see a troubled youth, and they want to help him. And when they see that African American before them, they see a thug, and they want to lock him up because of the long history of legalized oppression. It includes slavery, includes lynching, includes convict leasing. If you want to see the role that the criminal justice system has played, read David Oshinsky's excellent book, Worse Than Slavery, which describes how after emancipation, the criminal justice system in the South was used that when you needed to get into cotton, you needed labor for some other reason, you just went out and arrested a lot of African American people on vagrancy charges and literally worked them to death because the sheriff would lease them to the plantations, and it was actually worse than slavery. The 2 most important decisions in every death penalty case is made by one person, the prosecutor. The decision whether to seek the death penalty, it's never required, and the decision whether or not to plea bargain the case. 99% of the prosecutors in this country are white. And every study that has been done, and they were all compared a few years ago by the General Accounting Office, and there have been more since then, show disparities in the way in which the death penalty is used. The most recent was by the Department of Justice, which looked at its own record in use of the death penalty and found that 3/4 of the people, and it's always discretionary, there are all these crimes for which the federal government can seek the death penalty. It's fairly rare when it does. But in 3/4 of the case where the federal government sought the death penalty, where Janet Reno signed off on the death penalty, the person who was a defendant was a member of a racial minority. In over half the cases, it was an African American. Nationally, African Americans, remarkably, although only 12% of the population, are the victims of half the murders that are committed in this country. And yet, if you look at death row, the people that are there on death row, 80% are there for crimes against white people. And if you look in the Deep South, where we have far more larger African American population, Georgia and Alabama, for example, where African Americans are 65% of the victims of homicide, you still find 85%. Georgia's carried out 23 executions since the death penalty was reinstated in 1976, and 21 of the 23 people executed have been executed for crimes against white victims. And I found out why that was in my practice. I was representing a young African American in the community that sends the most people to death row in Georgia, Columbus, Georgia. And I had read in the paper where the prosecutor had called a press conference, and he had said after my client had been arrested, "We've met with the victim's family, and they want the death penalty, and we are going to seek the death penalty, and we're going to get the death penalty." And as we started looking, we noticed that this was pretty typical behavior. At that time, there were 10 prosecutors in Columbus, all white men. This was in a community 35% African American. William Brooks was tried the first time I represented him in his second trial after getting it reversed by a jury that didn't have a single person of color in it. The judge who presided over his trial, Judge John Henry Land's father, Brewster Land, had been involved in 2 very well-known and highly publicized lynchings in the community. And as I looked at what happened in that case, it was clear to me that what Brewster Land had done out in the community with a rope and with a gun, Judge Land was doing in a courtroom by manipulating the way in which jurors were picked and the way in which the case was tried and the lawyers who were appointed to defend William. But what I became interested in was the fact that over and over again in cases where a white person, particularly a person of any prominence, had been killed, they would be called into the prosecutor's office and they'd be asked, "What sentence do you want in this case?" I remember talking to one fellow who was a contractor there, and he said, "Yeah, the prosecutor called me and said, 'Do you want the death penalty in the case where your daughter was killed?' And I said, 'Yes, I do.' And he said, 'That's all I need to know.' And he got the death penalty. And in the next election, when that prosecutor ran for judge, the contractor rewarded him with a $5,000 contribution to his campaign. But then we went to people in the African American community. We got all the obituaries, we got all the crime reports, and we started going to family after family after family. Did anybody ever come to you and ask you what you wanted? And of course, what we heard over and over again was not only did nobody call us and ask us whether we wanted the death penalty, nobody called us and even told us what was going on in the case. And I'll never forget when we took a recess during that hearing after all these families had come in and talked about their spouse or their son or their daughter or whoever it was that was killed. And there was a young African-American man, Morris Comer, I still remember him, who was testifying against my client. He was an event witness. He had seen my client fleeing from the scene after the crime, and he was there for other reasons. And we called a recess, and Mr. Comer came up to me and he grabbed my shoulder and he said, "Mr. Bright, the guy that killed my sister is already out on the streets." And then, of course, my own client's father, William Brooks's father, John Brooks, a man who had served his country, made a career in the military, was shot and killed on the streets of Columbus, Georgia. And I asked the prosecutor, who so vigorously prosecuted my client at the first trial and was now a judge, I said, "Judge Smith, did you know about the death of John Brooks on the streets of Columbus?" He said, "No, I don't know who that was." The death of this black man hadn't registered at all in the prosecutor's office. And the death penalty is a matter of place because it's places like Columbus and places like Houston. It's the white flight suburban communities which are the places which send a vastly disproportionate number of people to death row. People ask me, well, why is it that Houston has so many people sentenced to death and so many people executed? And the answer is two words: Johnny Holmes, the district attorney in Houston. If you commit a crime in Houston, you're going to get the death penalty. You commit the same crime in Dallas, you're not. Commit a crime in Philadelphia, you're going to get the death penalty. Commit the same crime in Pittsburgh, you're not, just simply because of who the prosecutors are. And the same is true in New York, the same is true in Mississippi, the same is true. And even this federal study that just came out, where would you guess, if you're going to have the federal death penalty for drug kingpins, you think, where are the drug kingpins in this world? Detroit, maybe? New York? Where would you think most of the federal prosecutions would be? Would you guess Norfolk, Virginia? But that, of the 94 federal districts, 40% of the cases in the Eastern District of Virginia, 2 of the New York districts, and Puerto Rico, whose constitution provides that there will not be a death penalty. But they're seeking, just like they'll do here in Wisconsin, or maybe are already doing, they go down to Puerto Rico and seek the death penalty in the courts there. When I talk about inequity, I'm talking about poverty and the death penalty for poor people. A great Supreme Court Justice, Hugo Black, would say occasionally in his opinions and in his speeches that the courts were to be havens of refuge for those who were outnumbered, who were unpopular, and who were despised. Justice Black also said there can be no equal justice when the kind of trial a person gets depends upon the amount of money he or she has. And he said that in the case of Gideon versus Wainwright, in which a very close Griffin versus Illinois, a very close case, 5-4, in which the Supreme Court held there was a right to transcripts, that poor people had a right to a transcript of their trial for purposes of appeal. As recently as just a few years ago, some members of the Supreme Court of the United States, including Clarence Thomas and Anthony Scalia, said they thought the Griffin case was wrongly decided in giving poor people the right to a transcript. That was in 1956. In 1963, in Gideon versus Wainwright, the Supreme Court said that in our adversary system of justice, lawyers were necessities, not luxuries, and that a person can't be assured a fair trial unless counsel is provided. But we remain very far short today of the guarantee of equal protection of the law and due process of the law and the decisions of the Supreme Court in Griffin and Gideon versus Wainwright. We all know, don't we, that the kind of trial a person gets depends upon the amount of money they have. And anybody who suggested otherwise would be laughed at. And in fact, Judge Alvin Rubin of the Fifth Circuit, in upholding a death case, was very candid about it. He said this, and I'm quoting from the case of Riles versus McCotter. The Constitution, as interpreted by the court, does not require that the accused, even in a capital case, be represented by able or effective counsel. Consequently, accused people who are represented by, quote, not legally ineffective, end quote, lawyers may be condemned to die when that same person, if represented by a competent lawyer, would at least receive a life sentence? It doesn't have the same ring to it, does it, as Justice Black's comment that there can't be justice when the kind of trial a person gets depends upon the amount of money they have. Let me read it to you again. The Constitution, as interpreted by the courts, does not require that the accused, even in a capital case, be represented by able or effective counsel. That's in a decision condemning a man to die who was put to death by the state of Texas. And there's no question that it's true. There's no question about that. My client Judy Haney was represented by a lawyer who stood up during her trial to make an objection and fell over and couldn't get up again because he was too intoxicated. And Judge Jerry Fielding there in Talladega just simply had the sheriffs pick him up and he told the jury, we're going to dismiss court for the day, we'll be back tomorrow. He sent Mr. Blair, the lawyer, to the jail, along with Miss Haney, my client. And the next morning he produced both client and lawyer from the jail, and trial resumed. You may say, well, it's kind of dramatic, but what difference did it make? What difference did it make? That's what everybody says to me. I'll tell you what difference it made. Judy Haney killed her husband, a man who had abused her and her children for 15 years. She testified that he had broken her arm and broken her nose and abused the girl and abused the boy that they had had. And the prosecutor ridiculed it and said, did you see any evidence at all to support that? She just made that up. All you had to do was go down to the hospital. The hospital records were right there. Broken nose, broken arm. Other abuse of the children. It was never presented to the jury. Juries don't know things unless the lawyers tell them. The jurors that condemned Horrence Duncans to die wrote to the governor of Alabama and said, we would have never voted to kill this kid if we had known he was mentally retarded. But we didn't know because no evidence was put on. Because the lawyer never bothered to go across the street to the school to see that he had been in special education classes, to see that he had an IQ of 56, that this was a profoundly mentally retarded man that they had condemned. But I was too late. They executed him. 3 times it took. His father stood there and watched as the state of Alabama kept trying and trying to kill him, and finally they did. Jack House, after he had been condemned to die in Georgia, meets his lawyer in the jail. Not because the lawyer's there to visit him, but because the lawyer's there on state and federal drug charges. 2 cases recently upheld, one in Missouri and one in Alabama, in which lawyers exploited their clients sexually. And I could go on with other stories, but let me take you to Houston, because that's the capital of capital punishment. And I want to tell you about the trial of a man named George McFarland. This is the report of his trial in the Houston Chronicle. Seated beside his client, defense attorney John Benn spent much of yesterday's trial in deep sleep. His mouth kept falling open and his head lolled back on his shoulders, and then he'd wake up just long enough to catch himself. And it happened again and again and again. And each time he would catch himself and he would sit upright, and when he opened his eyes, there'd be a different prosecution witness on the stand, describing another aspect of the case against his client, George McFarland. And when the judge finally called a recess, Ben was asked, how could you sleep when you were supposed to be defending a man in a capital murder case? The 72-year-old longtime Houston lawyer explained, it's boring. Now, my students ask me, how does a judge preside over a trial like that? How does a judge who's taken an oath to uphold the Constitution of the United States, including the 6th Amendment right to counsel, sit in a case like that? Doug Schaefer was the judge in that case, and Judge Schaefer said, well, the 6th Amendment guarantees you a right to a lawyer, but it doesn't guarantee you that the lawyer has to be awake. Now, that's what we call a strict construction, wherever there was. And the sad thing about that is that this is only one of 3 people in Houston, in one town. 3 people, George McFarland, Carl Johnson, Calvin Burdine, all represented by lawyers who slept through their death penalty trials. Just recently, a federal district judge in Houston, a fairly conservative judge, Judge Hittner, granted Calvin Burdine relief, saying that the fact that his lawyer slept through long periods of time in his trial denied him his 6th Amendment right to counsel, and he made what I thought was a fairly unremarkable observation in his opinion. He said a sleeping lawyer is the equivalent to no lawyer at all. State of Texas appealed to the United States Court of Appeals for the Fifth Circuit, and I was there for the oral argument. So I'm giving you an eyewitness account of this. That the Attorney General's office for the state of Texas argued that they should set aside that grant of habeas corpus relief, that they should put Calvin Burdine to jail because, as a lawyer put it, a lawyer who is sleeping is no different than a lawyer who's under the influence of alcohol, a lawyer who's under the influence of drugs, or a lawyer suffering from Alzheimer's. And since the court had upheld cases in all of those instances, and believe it or not, the court engaged counsel on that issue. Judge Benevisti leaned over the bench and said, well, counsel, don't you think there's a difference in a lawyer who's intoxicated, and we can kind of see how intoxicated he is and how bad he was? There's a difference between an intoxicated lawyer and a lawyer who's completely unconscious. Isn't there? And I must say, as a member of the legal profession, I was embarrassed to be there for this argument, and I was glad that a group of fifth graders didn't come in there, because I think the fact that the state of Texas appealed that case, and the fact that they made that argument, and the fact that 3 federal judges took it seriously is a disgrace to our legal system. And I'll tell you what's going to happen. As soon as this election's over, they're going to reverse that case, because the other person, represented by that same lawyer, Joe Frank Cannon, Carl Johnson, has already been put to death by the state of Texas, and there's no relief for him, even though his lawyer slept through the trial. It gives a whole new meaning to being represented by the Dream Team. And yet, last year when the state of Texas adopted an indigent defense bill that was so modest it was an embarrassment how bad it was, the governor vetoed it. In the criminal justice system today, for reasons that I've elaborated on elsewhere, and you can read the details and the examples and the reason, in the criminal justice system today, it is better to be rich and guilty than to be poor and innocent, and that's not equal justice. And at some stages of the process of review, the Supreme Court has held that there is no right to counsel at all. In the state of Georgia, a man named Xavier Gibson, whose IQ was found on different tests to be 76 to 82, stood in front of a judge at his very first state post-conviction hearing, and the judge says, Mr. Gibson, are you ready to go? Judge, I need a lawyer. You're not entitled to a lawyer. Are you ready to go? I don't know what we're doing. I don't know what's going on. Well, you can call some witnesses. I don't know who to call. Here's a man, mentally retarded man, totally bewildered, standing in front of a Superior Court judge, state represented, of course, by an expert litigator that does nothing but capital habeas corpus. And they let the state put on its case, and the judge would ask, Mr. Gibson, you want to cross-examine? Cross-examine? I don't know. What's that cross-examine? You ask questions. Well, I don't know what to ask. Well, then sit down. That's the way we decide whether a human being is going to live or die. A man who's mentally retarded, whose transcript of his trial runs a full 400 pages long, the trial where he was condemned to die. In Texas, although somebody will tell you that people in Texas all get complete review of their cases, I'm going to tell you, and I'll cite you the case of Albert Cantu, whose lawyer missed the deadline for state post-conviction, missed the deadline for federal, and he was put to death without any state or federal review of his case, just simply because his lawyer never came to see him and wasn't aware of the statutes of limitations that affected his case. In Alabama right now, there are 30 people that don't have lawyers, condemned to die, have right to go to court, and don't have lawyers, and there's a 1-year statute of limitations. It's already run on some of them. And they're just sitting ducks, and they're going to be executed. And that's not equal justice, not when Frank Keating can get a lawyer and go in and get habeas corpus relief, but the poor person convicted and sentenced to die cannot. And the death penalty is a matter of iniquity. The mentally ill, our client Varnell Weeks, executed a few years ago, who would stand in his cell naked and smeared in his own feces, talking to people that no one else could see and hearing voices none of the rest of us could hear. Charles Rumbaugh, who was only 17, who self-mutilated himself and was given the right by the state of Texas to withdraw his appeals and be executed. Pernell Ford, the most recent person executed by the state of Alabama, who came to court dressed only in a sheet wrapped around himself, waived his right to a lawyer, turned over counsel table, tried to call people who were dead as witnesses and put them on, and was allowed again to withdraw his appeals and be executed. We are putting to death the delusional, the paranoid, the brain damaged, the chemically imbalanced, the abused and neglected, the mentally retarded, people who through no fault of their own have been punished and tormented all their life. People that we sent to Vietnam and subjected to the most awful trauma imaginable, who came back with post-traumatic stress syndrome, who came back addicted to drugs, who came back with various problems. There is a shocking inequality, in my opinion, that we would have such a severe and extraordinary punishment for the poorest and the most powerless among us, while those who sit in boardrooms and plot the addictions of our children and a whole generation of people, fraud, deceit, and lies, with the help of the power lawyers that they can afford, pay no criminal penalties whatsoever and live in luxury. We're in a cynical time when people don't believe in redemption, but I am here to tell you that I have seen it in representing people. I represented a young man named Tony Amadeo and had the privilege of arguing his case before the Supreme Court of the United States. And I'll just tell you real briefly. He wasn't innocent. He was guilty at age 18 of going AWOL with two other people from the Marines and going to a little county in Georgia and killing a man for his wallet. No question he did it. He got the death penalty. We found out later that the prosecutor had rigged the juries on the basis of race. He had told the jury commissioners to underrepresent African Americans, so we got a new trial. And ultimately, through a lot of hard work, we got Tony a life sentence. He called me a couple of years ago to ask me to come to his graduation from Mercer University. Here is a kid who, at age 18, just a little after his 18th birthday, the state of Georgia says is so beyond redemption that he should be eliminated from the human community. I saw him graduate summa cum laude from Mercer University. And I know that people are much worse, much more than the worst thing than they ever did in their lives. This punishment is corrupting our courts in the states where we have it. The governor of California announced that he would campaign against justices of that state's Supreme Court unless they changed their votes on the death penalty. They didn't, and he did. And he got Rose Bird and two of her colleagues voted off the court. In Texas, a man named Stephen Mansfield ran for the Texas Court of Criminal Appeals after the court, one of the most conservative courts in the country, and one of the most conservative judges on that court wrote an opinion setting aside a death case. Because, you can't affirm every single case. I mean, the California Supreme Court, after the purge, actually did affirm 100 consecutive cases. But most courts occasionally find a case that, for one reason or another, has to be reversed. And this particular case had clear legal error. And Judge Campbell wrote the opinion setting aside. A fellow named Stephen Mansfield ran against him. Before the election, it came out that Mansfield had lied about where he'd been born. Most people know where they've been born. Lied about, said he had never run for public office before. He actually had. He said he had extensive criminal law experience. He had none. He had been fined for practicing law without a license in Florida, which was a misdemeanor. He owed $100,000 in back child support. All this comes out before the election, that the fellow has no experience as a judge, no experience in criminal law. He's running for the highest court in the state. And on election, the day after the election, he had 54% of the vote. Judge Stephen Mansfield, the Texas lawyer, said he was an unqualified success, which I suppose he was. During a somewhat less than distinguished career on the court, he has so far been cited by the Humane Society for locking his dogs in the car, windows rolled up, and arrested for scalping his complimentary football tickets at the University of Texas football game. Penny White was voted off the Tennessee Supreme Court, campaigned against her for one death penalty case decided unanimously. We have been willing to sacrifice the independence and the integrity of our courts for results. And we are even willing, I understand, to sacrifice the innocent. I was in a discussion with Congressman McCollum from Florida, and he said at one point, well, you know, we're fighting a war on crime, and when you fight a war on crime, there are going to be some casualties, some innocent casualties. That's just what you have to do. When I went to law school, they taught us that it was better for 10 innocent or guilty people to go free than for an innocent person to be convicted. But today, the poor, the black, the brown, it's okay to execute a few innocent people to fight this war on crime. And increasingly, there is this effort in the federal courts to reassert states' rights, to go back to that era before the federal courts came in and played such an important role in changing things, to go back to that era, and we probably will decide in the next few years whether we are going to take a complete hands-off stance to what Texas and Georgia and all these states do, or whether we will continue to have some federal intervention, some supervision by life tenure courts as opposed to the elected courts. All these, our commitment to racial equality, our commitment to fairness, our commitment to decency, our commitment to the rule of law, have been sacrificed as part of this war on crime, and the death penalty has been the ultimate weapon in this war. There is a need to re-examine this war. There's a need to re-examine a war that we're fighting against our own people, that we're fighting against our own children, that we're fighting against the mentally ill and the mentally retarded, a war that has literally become class warfare fought top-down against the poorest and the most powerless people in our society. And we should be grateful to the American Bar Association, to Governor Ryan and others who have sparked this discussion. I hope those of you who are at this law school, either have graduated or will graduate, will provide the leadership that has so often been missing in the discussion of crime. I hope, if nothing else, that you will refrain from the demagoguery that has been so much a part of the crime debate, the demeaning of the Bill of Rights as nothing more than a collection of technicalities. I hope you will refrain from taking cheap shots at judges who abide by their oath and uphold the Constitution, even in controversial cases. But you can do so much more. You can help build indigent defense programs in places that don't have them. And in the Deep South states, we don't have indigent defense. There is no public defender in Georgia, in Alabama, in Mississippi, in Arkansas, in Texas. Often the indigent defense business is just bid out to the lowest bidder. Any lawyer who enters a bid gets the business. Or lawyers are appointed individually and are given token amounts of money. You can respond individually by providing your services to the people who most desperately need them. There are lots of desperate needs, and I've only talked about one of them. But I would urge you to think about this, because what I see in my practice is increasingly the legal profession becoming irrelevant and the courts becoming irrelevant to so many people in our society. If you're Delta Airlines and you're suing the bank, it's great. You can get Griffin Bell and you can get the big law firms and you can get justice in our courts. But if you're a poor person in prison, legal services lawyers can't even represent prisoners anymore. If you're a poor person like Xavier Gibson on death row without a lawyer, there's no access to the courts whatsoever. If you're a poor person like Gregory Wilson facing the death penalty in Kentucky, who's represented by a lawyer who doesn't have an office, who has inability to speak coherently, who has a big Budweiser sign over his desk, who gives his client a card and tells his client, call me at this number, and when the client calls, they answer Kelly's Keg. It's a bar. And the guy over and over again says, please, Judge, give me a real lawyer. My life is at stake. And the judge says, no, that's your lawyer. That's, if you can get somebody else, great. The money that's available to be made in the legal profession today is obscene and an embarrassment to our profession, and it will make it more irrelevant, I'm afraid, as time goes by. But I would urge you, those of you who are students, to remember that it's no sacrifice to receive the same income as is received by teachers, farmers, people on the assembly line, and other good, decent, hard-working men and women who give their lives every day to their communities and to their families. And regardless of what the national government does, and regardless of what the Supreme Court does, and regardless of what the states do, you can show your commitment by representing people, by going to communities all over this country where there has never been a lawyer who would question the status quo. Never been a lawyer who would give an African American the same quality of representation of white people. Never been a lawyer who would give the poor the same quality of representation as the rich. You have, if you're willing to live modestly and work hard, it's what we do at my little office. Sometimes people say, you've been practicing law for 25 years and you're only making $25,000 a year. I say, well, you'd rather be doing something and get nothing for it than be doing nothing and get something for it. And some of us have the privilege of spending our whole lives doing what Holmes talked about, wearing our hearts out in pursuit of the unattainable. And very few people get to spend their lives doing that. You have the opportunity to become what Martin Luther King in one of his many great sermons called drum majors for justice, people who would stand up and speak the truth no matter how unwelcome it may be and how uncomfortable it may make the listener. And one who gives his or her life to serving others, to feeding the hungry, to clothing the naked, and particularly important for lawyers, to visiting those who are in jail. And I encourage you to adopt his goal. I just want to be there in love and justice and in truth and in commitment to others so that we can make of this old world a new one. Don't forget what one lawyer can do in one case. Just like the Underground Railroad, moving people to safe passage by giving them the consultation, the investigation, the representation that they're entitled to. And bearing witness to the injustices that go on in the courts until we do something about them. And raising larger questions, which I want to leave you with as I close, that must be raised about what kind of society do we want to have? What kind of people do we want to be? Do we have the courage to wrestle with the moral ambiguities and the fact that some people are much more than the worst thing that they've ever done in their life? Do we have the humility to recognize the fallibility of our court system? Do we have the courage to recognize the dignity of every person, even those who have offended us most grievously? Do we want a vengeful society? Do we want a hateful society, a society that turns its back on its children and then executes them, that denies its mentally ill the medicine and the treatment they need and then puts them to death when the demons are no longer kept at bay? That gives nothing to the survivors or the victims of crime than a chance to ask for the maximum sentence and to witness an execution. The Constitutional Court of South Africa addressed some of these questions in deciding whether the death penalty was appropriate for that country. And it unanimously concluded, in the words of one member of the court, that South Africa was moving to a new time. It was a society in transition, from one of hatred to understanding, from one of vengeance to reconciliation. And that there was not a place for capital punishment in that society, despite the crime rate, despite the violence, and despite a history of racial violence and oppression. I think if we ask these questions and examine these things and think about what kind of people we want to be and wrestle with the answers to those questions, I think we'll conclude ultimately that, like slavery and segregation, the death penalty is a relic of another era. And that we will finally join the rest of the civilized world in making permanent, absolute, and unequivocal the injunction, "Thou shalt not kill." Thank you. Very nice. Thank you very much.
Thank you very, very much, Mr. Bright. I'm sure I'm not speaking just for myself when I say that I had very high expectations for this talk tonight, and they were greatly exceeded. Thank you very much. Steve has agreed to respond to questions for a few minutes. What I would like to do is if you have a question from the floor here, if you can speak, announce it as loudly as you can. I'll repeat it so that people listening in the other rooms know what the question is, and then we'll get the response. Then, before we completely disband, I have a few final closing remarks to make. But anyone have any questions for our speaker, please? Alta?
Political action often follows a single dramatic scandal associated with a known individual. In the death penalty area, it's always seemed like the proof that somebody who is definitively shown to be innocent and yet was executed is what will finally turn the tide politically. I was wondering if you could describe the likelihood of that occurring. I don't know what the state is of the evidence that's retained after executions and the possibility of using DNA evidence and other kinds of technologies to look back at people who've already been executed.
I can't
I can
short-circuit
paraphrase
that.
it real quick, which is how likely is it that we might show that some of the people that have been executed are actually innocent? As I said, in so many cases, in the Ninth Circuit, one of the dissenting judges said this in the case of a very dubious case in Tommy Thompson's case in California. He said, only two people that are ever going to know what happened in this case. One, the man we're putting to death, and one, the informant who testified against him. Same thing is true in the Ronald Chandler case, the first federal death penalty case that is out of Alabama. Somebody kills somebody, they get caught by the police, and they say, Chandler put me up to it. And Chandler wanted me to kill this guy because he was going to expose his marijuana growing. Now Chandler says, I didn't tell the guy anything. And in fact, the evidence was this fellow had tried to kill the same person on another occasion when clearly Chandler had nothing to do with it. We'll never know the answer in those cases, in the misidentification cases. I was on a program just recently with a woman named Jennifer Thompson, a very remarkable woman who identified a man. She lives in Winston-Salem, North Carolina, and she identified a man, and he was convicted of rape. And she told about the crime took a long time, 20 minutes, how carefully she studied the face of the assailant while it was going on, how convinced she was that he was the right man, how when the case was reversed later on by the courts, there was a rumor going around that another man had bragged that he had done the crime. So at the trial, they brought him in. She looked at him. She said, no way, I never saw this man before in my life. She identified the other fellow. Again, he's convicted a second time. And after 11 years, the police come and say, Jennifer, it wasn't that guy. It was the other guy that bragged about it. And she told her story. It's been made into a frontline program called What Jennifer Saw, about how convinced she was, absolutely to a moral certainty. Seldom do we have biological evidence that makes it clear that we're wrong. One of the things that she explained so well is the fact that the fact that you're sure has no relation whatsoever to the accuracy of the identification. But back to your main question, one of the things that's been very disturbing to me has been that in some cases where there has been some DNA evidence, particularly in Virginia, the state has gone to great lengths to destroy the evidence so that it couldn't be tested. In the Joe Odell case, the state destroyed the evidence. Roger Keith Coleman, there's actually a book called May God Have Mercy about the Roger Keith Coleman case in Virginia that makes the case that Coleman may very well be innocent of that crime. Turned out just recently, within the last few weeks, they found out that a crime lab in California actually still has the biological evidence in that case. And the Richmond newspaper and some other people want to test it. And the state of Virginia wants it back and is arguing that they're entitled to destroy that evidence. Now, it's awfully hard. The state has possession of the evidence. And one of the things that's been extremely disturbing to me has been that now that DNA evidence has cleared a lot of people, and that's the other place that's shown us, not just the 89 people freed from death row, but the fact that the Innocence Project at Cardozo Law School has gone. I mean, we had a fellow in Atlanta who spent 16 years in prison for a crime he clearly didn't commit. The DNA evidence proved conclusively he was not the person. So we know that the system is making these mistakes, but it's only a very small number of cases that have biological evidence. Usually it's an identification and circumstantial evidence, often a confession. A lot of people think, well, surely somebody that confessed to a crime wouldn't be guilty of it. Earl Washington is, of course, a perfect example of a person who confessed to a crime that he didn't do. He was mentally retarded. It was fairly easy to get him to confess. There was just recently a case in Texas where the DNA evidence proved that a fellow who confessed because he was told if he didn't confess and point to the other guy, he'd get the death penalty. So he did point to the other guy. They both got convicted. It turned out both of them were innocent. But we often don't have cases like that. I still think there's a case in Georgia called Wayne Felker who was executed. Medical examiner first said the person had been dead a certain amount of time. Turned out Felker had an alibi. Changed it by 2 weeks, which is a rather dramatic change. And the Atlanta Constitution got the evidence, but I was just talking to the reporter yesterday, and she said they kept the evidence so poorly that they're not sure they'll ever be able to actually do the DNA test to prove it, but they're trying. They did get it, and it's at some lab. So that may prove that Mr. Felker was not guilty of the crime. So the problem is it's very hard to prove you're innocent. That's why the requirement at trial is that you prove guilt beyond a reasonable doubt. It's very hard to prove a negative. Yes, ma'am.
How do you explain the fact that so many people in this country are in favor of the death penalty?
Question was, excuse me.
Compare that to other Western culture. Why is that?
Question was, how can this country have so many people who are in favor of the death penalty?
Well, I would trace that to the emergence of crime as an issue. For a long time, the favorite issue was, of course, as you well know in Wisconsin, communism was a great issue for people to use. Richard Nixon used it very effectively in getting elected to Congress and moving his career along. Richard Nixon also realized in 1968 that wasn't working anymore, and when he accepted the Republican nomination for president, he promised to fire Ramsey Clark, the Attorney General of the United States. Of course, obviously, it'd change if there was a change in administrations. Lee Atwater coached the Republicans on how to effectively use the crime issue. And of course, the Willie Horton ads were the icing on that cake in destroying Michael Dukakis. And then, of course, Governor Clinton came back from Arkansas to make a big deal out of putting to death a brain-damaged man named Ricky Rector when he was running in 1992, and was seen as having insulated himself from being accused of being soft on crime. I think the crime debate, when I referred to the demagoguery on the crime debate, we haven't really had a debate. We haven't had a thoughtful discussion about crime. What we've had is a sort of ridiculous one-upsmanship about who can be the toughest on crime, who can be most in favor of the death penalty, who can be most in favor of doing away with the review process, who can be most in favor of life without parole. All of this sort of, how do you show how tough you are? I think the death penalty is a great soundbite for people to prove how tough they are. And nobody looks at what's actually going on in the courts of this land. I think George Will hit it right on the head. People don't think the post office works very well. They got to go down and see how the court system works, particularly the criminal court system, where poor people are involved. I go to courthouses all over the South, and I watch, and I'm talking about just regular, and this is something we ought to be very concerned about because people in these communities see this. I go to a courthouse, it looks like a slave ship is docked outside the courthouse. And this group of African-American men are herded into the courtroom, literally herded in. And then they call the docket. We were just up in Greene County that they called the docket, and many of the people plead guilty, even in felony cases, without a lawyer. They'll come up, you have a lawyer? No, I don't have a lawyer. I've been in jail. How would I have a lawyer? Well, talk to this guy who's the prosecutor. Other people, they appoint one of 2 contract lawyers who've never talked to these people before. They whisper around for a little while, and then they plead guilty. And then they're sentenced. And the other day, Monday, as they were leaving, one of the mothers of one of the clients said, as they're going downstairs, said, gosh, darn, that's a railroad in there. And interestingly, we came back after lunch, and the judge took the bench who hadn't heard that comment. And the judge banged the gavel and said, all right, let's get this train running. And, Clarence Darrow said the criminal justice system was the only railroad in America that worked. But I think that the fact that the people are poor, the fact that we're dealing with mostly minority people, we're destroying the black community with the criminal justice policies that we have, not just the death penalty, but the fact that we're locking so many people up, locking people up on all these drug charges. I don't think those policies would ever be acceptable to the American people if they applied to white people the way they apply to black people. I don't think they'd ever be acceptable to the American people if they applied to middle-class people or other people. But I think most people, when Congressman McCollum says that it's okay to execute an innocent person, I don't think he's thinking about himself or a member of his family. It's the other. It's these people out. And the crime debate is very much like the debate that we have over war. We're conditioned to believe that people that we kill in war are not really human beings, that they're demons, that they're gooks, that they're Japs, that they're dehumanized in some way. That's exactly what we've done with the crime debate, that these people are animals, that they're predators, super predators. You know, I've practiced criminal law now for 25 years. If there were any super predators out there, I would think I'd have met at least one by now, because, I mean, I've done nothing but capital work for the last 20 years. And I've yet to meet the monsters. I read in the picture of a child after one of these school shootings. It says monsters. I've never met a monster in the people that I've represented. I've met some people that have had some hard times and done some hard things, and certainly some people that ought to be punished, and people that the community needs protection from and ought to be punished severely. But this whole notion that there are these disposable people, these animals and predators, I think has contributed immensely to the popularity. And I think now what's happening is that when you see a Carla Faye Tucker and when you see an Anthony Porter and all that, and you realize the human cost of this, that maybe that will tap. My real worry about what's going to happen is that after this election that nobody will pay any attention anymore. Because while everybody's paid a lot of attention to Texas this year, just 2 years ago, Koppel had a program on Nightline where his theme was, we're killing all these people down here, and nobody even knows about it. Even people in Huntsville, where the executions are taking place, don't know what's going on. They're just, people are coming through. It's not even in the local newspaper anymore. And that's what's most worrisome, because when the death penalty become routine, as it has in the South, I mean, now the judges don't now they don't even give oral argument in a lot of the cases. I mean, they don't even, they'll decide them on a phone call. And that would have been unheard of 25 years ago. And now it's just, it's a death case. Get it out of here. Let's get to something really important, like some corporate law thing or something. The bread and butter case, not a death case. And we've got a lot of judges now that never have ever voted. Judge Ludick, mentioned often as a Supreme Court possibility, he's never voted in his life to reverse a death case. In his career on the Fourth Circuit, he's been on there for a long time, ever since President Bush appointed him. Edith Jones never reversed a death case. Never will. I mean, that's only half the story. They're never going to. And if they get on the Supreme Court, they're never going to. But at any rate, gone and beyond. You had a question? Yes, ma'am.
I was wondering, do you think that the changing demographics of this country is going to affect this issue politically or nationally? For example, these prosecutions so hot on the death penalty are not going to be able to move to higher office because the constituents out there in the county are
I hope so.
Question was whether the changing demographics of the country will eventually have an impact on this issue.
Well, I hope so. I think Texas is an interesting state to look at in that regard. Before long, Texas will be roughly a third Hispanic, a third black, a third white. The Texas Court of Criminal Appeals, all white. No Hispanic, no African American. They're deciding the lives of thousands of brown and black people every year on that court. I think if the courts don't, at some point, begin to reflect the society more, and I'm talking about trial judges, juries, appellate judges, prosecutors, all of that, I think our courts are not going to have much legitimacy or respect in the public. But we have so far to go to catch up because we've discriminated for so long on people of color becoming members of the legal profession. I mean, in Georgia, you couldn't even go to the law schools in the state if you were a person of color until just a short time ago, short in the great scheme of things. And now, after the Hopwood decision, we have a lot of law schools that have very, very small racial minority enrollments. And I think that's a real problem for the legal system, and I don't understand this resistance to it, because it seems to me that it just makes common sense that if you've got a very diverse society, that diversity can be a strength if you have it there. I mean, if you read the tributes that some of the justices, particularly O'Connor, wrote about Thurgood Marshall, it was like, holy mackerel, I didn't know they did things like that. They discriminated against black people in the South, because here was a guy who had actually been told, you better be out of town by sundown. And you read that piece that she wrote in the Stanford Law Review about Thurgood Marshall, and it's like a whole world that she's never known. Being told by this fellow justice on the Supreme Court. I mean, that diversity is valuable for our courts. We don't have that on most of our courts. And I think, as I said, I think that hurts their credibility and so forth. So politically, it may be. I mean, I think this year, we'll see what happens in 2 weeks. I mean, it would be interesting, although that's probably not the major issue in this campaign, or maybe it's not an issue at all. But I thought it would be interesting if a candidate, we'll know something is changing. If a person loses an election because they're too tough on crime, as opposed to being soft on crime. But if the governor of Texas can get elected to office, I mean, with what's going on in Texas and with the sort of charade that goes on in those courts there. I don't know what that says about our commitment to fairness and due process.
I'm very reluctant to cut this off, but I think I need to close the formal portion of the program before too many people have to leave us. Again, there will be a reception beginning in a moment. I have one final order of business to take care of. On behalf of the law school and university, Steve, I want to thank you very much for your fine presentation today. It is a tradition at this law school to offer a very modest but heartfelt token of our appreciation for speakers in your position. And if I could be tolerated, about 3 sentences of background so people know what you're getting.
Me too.
This current law school building is about the 4th version that has been on this site over the course of 100 years or so. The original law school building was a red brick, semi-Gothic structure that had the old-fashioned gargoyles up on the corners of the building. One of those gargoyles survives and is in all his or her glory out near the glass doors on the 2nd floor of this building. Several years ago, we cast some of those gargoyles in miniature, and it has been our custom to provide those to speakers who have done such a fine job. So, this will be yours.
I don't know what to say. No, that's
The gargoyle says, University of Wisconsin Law School to Stephen B. Bright, the 2000 Thomas E. Fairchild Lecturer.
Thank you very much. Thank you. Thank all of you for coming. Thank you. Evan, thank you very much. Okay. All right. Thank you.
The reception will follow, as I mentioned. It is the Sheldon Lubar Commons on the 7th floor of the faculty tower, room 7200. We have some people outside the doorway. If you need some help getting pointed in the right direction, they will be happy to do that. Thank you all very much.